If you're in the USA right now, whether you're on an H1B visa, waiting on a green card, on a student visa, or getting ready to apply for citizenship, at least one decision made in the last 30 days is about to touch your life directly. A federal judge just ruled that the $100,000 H1B fee is illegal. At the same time, citizenship application fees are set to jump from $760 straight to $1,330. And for people applying for a green card from India, the EB2 category has been completely shut down for the rest of this fiscal year. All of this happened in the last 30 days, and if you didn't know that, you're already behind. I'm not pulling any of this from rumors or YouTube gossip. Every single point comes directly from USCIS, the State Department, and federal court records, so stick around, because the last part of this video might decide the future of your case. Welcome back to the channel, where every week we bring you the most important USA immigration and visa updates. No drama, no fear-mongering, just verified facts and a clear explanation of what each update actually means for you. In today's video, we're covering 6 major updates: the July 2026 Visa Bulletin and the green card situation, a new court decision on the H1B visa, a proposed increase in citizenship fees, new USCIS rules every applicant needs to know, TPS and asylum updates, and what's changing on the enforcement side. If this is your first time here, hit subscribe, because immigration policy is moving so fast right now that missing the next video could genuinely cost you. Let's start with the thing that matters most to millions of people: the green card. The State Department released the July 2026 Visa Bulletin, and there are 2 major signals in it. First, due to high demand and heavy number use, the EB2 category, along with unreserved EB5 investor visas, has become unavailable for applicants from India for the rest of this fiscal year, meaning no new approvals until October, when the new fiscal year begins. Second, China's EB2 category is under similar pressure, and if demand keeps climbing, the final action date could retrogress or the category could become unavailable too. This isn't just numbers. If you're in the EB2 India category and your priority date isn't current yet, you're looking at a wait until at least October, with no guarantee things improve after that. On a more positive note, the family-based F2A category is current for filing in the July Bulletin, so if you have eligible family members, now could be the right time to get that paperwork moving. And here's something very few people are talking about. USCIS is still using the stricter final action dates chart for employment categories, rather than the more lenient dates for filing chart, which means only applicants whose priority date is already current can file for adjustment of status. The old approach of just file and see what happens won't work anymore. Now let's talk about H1B, because a major legal decision just came down. Remember the proposed $100,000 fee on H1B petitions? A federal judge in Boston ruled that fee unlawful, saying it essentially functioned as a tax that Congress never authorized. Huge relief for both employers and applicants, though the administration could still appeal, so this chapter isn't fully closed. But alongside that good news, other restrictions are quietly building. First, the Department of Labor's wage rule. In March 2026, DOL proposed a rule that would raise the required prevailing wage for H1B professionals by 21 to 33% depending on experience level, making it significantly more expensive for employers to sponsor H1B workers. Second, the revised Form I-129 now includes 5 new questions about your education, experience, and skills, answered under penalty of perjury, and immigration attorneys are saying these answers are being cross-checked directly against DOL's wage level analysis. A mismatch is now triggering requests for evidence. Third, denial rates are climbing. According to a recent National Foundation for American Policy analysis, denial rates rose significantly in the EB1 and national interest waiver categories in the last quarter of fiscal year 2025. So if you're an H1B holder or considering sponsorship, my direct advice is this: your petition needs to be airtight and consistent, because even a small inconsistency can now trigger an RFE. Next is an update that will hit the largest number of people directly: naturalization fees. The Trump administration has proposed a major increase to the N-400 citizenship application fee. Paper filing would rise from $760 to $1,330, and online filing from $710 to $1,280. And here's the bigger part. The reduced fee option of $380, which many applicants currently qualify for, would be eliminated entirely. This rule isn't final yet. DHS published it in the Federal Register, and the public comment period stays open until August 24, 2026, so the fee can't officially increase until a final rule is published after that date. What does this mean practically? If you're eligible for citizenship and have been thinking about applying, don't wait. Filing costs could nearly double soon, and if you fall into the low-income category, that option might disappear altogether. One more important detail. Starting July 10, 2026, an interim final rule takes effect, giving USCIS broader authority to reject or deny applications that lack a valid signature, and cases can be denied even after they've already been accepted for processing, with the agency allowed to keep the filing fee. That means one small clerical mistake could now cost you the entire fee and force you to restart the whole process. This next part is a little technical, but important, because it shows how the courts are actively pushing back against administration policy. A federal judge in Rhode Island blocked Trump administration policies that were delaying or halting asylum, green cards, work permits, and citizenship applications, ruling that the restrictions were arbitrary and capricious, meaning they lacked proper legal justification. In that same Rhode Island court, on June 5, 2026, an order vacated 3 internal USCIS policy memos entirely. Both cases show that immigration policy isn't being decided by the White House and USCIS alone. The courts are playing an active role, and many rulings are landing in applicants' favor. What does this mean for you? If your application was delayed or denied because of these now reversed policies, you may be able to benefit from the reversal, so it's worth discussing with your attorney right away. A few more updates worth a quick roundup. Lebanon's TPS designation has been automatically extended for 6 months, from May 28 to November 27, 2026. Asylum applicants under the Houston office's jurisdiction can now also be interviewed at the newly opened San Antonio Asylum office. On the enforcement side, Trump signed a $70 billion bill to fund ICE and Border Patrol through the rest of his administration, a major expansion of enforcement resources, meaning enforcement activity is likely to increase in the coming months. And a serious legal case is unfolding too. Civil rights groups have filed a federal lawsuit against the Camp East, Montana detention facility in El Paso, Texas, alleging poor conditions, inadequate medical care, and safety concerns. DHS has denied the allegations. All of this shows significant activity happening across every corner of the immigration system, both on the humanitarian side and the enforcement side. So, after hearing all this, the real question is, what should you actually do? If you're waiting on a green card, especially in the EB2 India category, keep checking your priority date regularly and keep your documentation ready so you can file the moment there's movement. If you're an H1B holder or sponsor, fill out the new Form I-129 questions carefully and get an attorney to review your petition. That's more important now than ever. If you're eligible for citizenship, don't delay your application, especially if you currently qualify for the reduced fee. And most importantly, don't make any decisions based on a YouTube video alone. This video is meant to keep you informed, not to serve as legal advice. Every case is different, and only a licensed immigration attorney can properly evaluate your specific situation. I say this repeatedly because I've seen people try to handle their own cases based on rumors or incomplete information, and one small mistake ends up setting them back years. So that was your complete July 2026 immigration and visa update, covering everything from green cards to H1B, citizenship fees, court rulings, and enforcement. One thing is clear, the U.S. immigration system is changing faster in 2026 than ever before, and the people who stay updated are the ones who protect their case with the right decision at the right time. If you found this video useful, do 3 things. Like it so it reaches more people who need it. Comment below and tell me which visa category you're in, whether it's EB2, H1B, F1, or family-based, so I can plan the next video around exactly that. And subscribe with notifications on, because the next big update could drop anytime. See you in the next video. Until then, stay updated on your case and make informed decisions on your immigration journey.